Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Today we got an interesting topic that a lot of people will find interesting, and I certainly find it interesting, and it's in regard to should you pay your mortgage if the party that's claiming you owe them money isn't anywhere in your chain of title. It's called tendering payment. So let's talk about that. Okay, so this is called the tender or exception to tender rule. And that the rule people hear and misunderstand. Most pro se litigants have heard some version of you have to tender the debt to challenge a foreclosure. That statement is incomplete and often wrong in quiet title cases. The correct legal framework, tender is required only when the defendant actually holds a valid enforceable lien. And in this case, we're talking about where the homeowner is the plaintiff and the bank is the defendant. So this is a quiet title kind of situation. So tender is required only when the defendant actually holds a valid enforceable lien and the plaintiff is seeking equitable relief to unwind a valid transaction. Tender is not a moral requirement. It is a procedural equity doctrine tied to valid interests. Why tender does not apply in many quiet title actions. Number one, a lien that was never attached. In many cases, a mortgage or deed of trust was never validly created, or the party asserting it never acquired it. Then there's nothing to tender against. Here's the teaching line. You cannot tender payment to someone who never owned the debt. Forgery is another one. A forged instrument is void ab initio. That means it's treated like it never existed. No rights flow from it. No equitable balancing is required. Judicial logic, courts do not condition relief on paying a debt to a forger. Assignment without authority. And this is the big smoking gun for many people I've seen. An assignment was executed by a dissolved entity, a servicer without power, a trustee acting ultra vires, an agent without authorization. Then the assignment conveys zero interest. So, a key teaching phase for this, equity does not require tender to invalidate a legal impossibility. Extinguished by law. Example, statute of limitations. If the debt is expired statute of limitations, you shouldn't have to tender payment, right? The debt was maybe satisfied or merged. Maybe you paid it off. You don't have to pay it again. If you have a judgment that was vacated, you don't have to pay that one either. If you have a prior foreclosure accelerated and never de-accelerated, like in New York, FAPA cases, you don't have to pay that either. An important distinction is you're not avoiding payment. The law already ended the lien. The paying ghost concept, this lands with people. Courts do not require people to pay ghosts. So let's explain this further. A ghost lien looks real in county records, but legally it has no body behind it. Quiet title is how courts exercise, and I mean exercise, those liens. Judges understand this concept instinctively. Here's some common tender mistakes. The pleading plaintiff is willing to tender, which you don't want to do if you're fighting a quiet title action. That's a mistake. Offering tender when arguing forgery or valid assignment, you don't want to offer to pay if it's been forged. Confusing I owe money with defendant owns the lien. Let's not confuse who you owe money to, guys. Don't want to do that either. Copy pasting tender language from wrongful foreclosure cases. Big mistake, guys. You don't want to do that. Tender is a defense tool for lenders. Don't hand it to them. So let's talk about loan modifications and valid authority here. This is big, guys. This happens to a lot of people. The myth people are sold. Borrowers are told, make trial payments to show good faith. But good faith does not create authority. A party must already have authority to modify and authority to bind the actual creditor. Why trial payments fail when authority is missing? No authority equals no contract. A loan modification is a new contract. If the offeror does not own the loan, is not an authorized agent, or acts outside delegated authority, then there is no meeting of the minds, no enforceable agreement, no obligation to perform, including those trial payments. So you cannot be in breach of a contract that was never legally formed. Servicers are not automatically authorized. Guys, repeat that again. Servicers are not automatically authorized. So servicers often collect payments, send statements, and process paperwork. That does not mean they can modify principal or interest, waive arrears, bind a trust or investor. Authority must be explicit, delegated, provable. Trial payments are conditional, not admissions. Trial payments are often framed as conditional approval, under review, subject to investor approval. That language is not accidental. It means the servicer is hedging. No authority has been exercised yet. The borrower is being asked to perform first. Key point: conditional authority is not authority. Tender logic applies equally to loan mods, just like the quiet title. Tender is not required when the property demanding has no enforceable interest. The lien is void or unenforceable. The actor lacks agency authority. Trial payments to an unauthorized servicer, or the loan mod version of paying a ghost lien. Why courts reject good faith arguments by servicers. Servicers often argue, well, the borrower failed to make trial payments. But courts ask, who had authority to offer the loan mod? Who would have bound by the acceptance? Where is the investor or trust approval? If the answer is unknown or not shown, failure to tender trial payments is legally irrelevant. Here's a teaching point, guys. The estoppel trap. Borrowers are often told, you accepted the trial plan, so you're bound. That fails when authority was lacking at inception. The agreement was ultra vires. Acceptance was induced by misrepresentation. Estoppel cannot create authority, ratify void acts, or bond a non-party creditor. Common loan mod tender mistakes: making trial payments without verifying authority, treating servicer letters as proof of investor approval, believing we service the loan, we actually can modify the loan, arguing breach without first proving contract formation. Why this question matters: people lose cases because they pay the wrong party. Others lose leverage by admitting authority through payment, and services exploit fear and misinformation. Paying doesn't always protect you. Sometimes it harms you. What tender actually means legally. The definition: tender equals an offer of payment required by equity. Applies when seeking relief against a valid obligation. Tender is not a confession. Tender is not required in every case. The first question is, who is demanding payment? Before any payment, who owns the debt? Who holds enforceable rights? Who authorized this demand, and can they prove it today? Here's a teaching line: if they can't prove authority, they can't demand tender. And that's something you guys got to remember. When tender is required, okay, let's look at it the other side. Given balanced credibility by acknowledging reality. Tender may be required when the debt is valid, the lien is valid, the creditor is properly identified, the plaintiff seeks equitable relief undoing a valid transaction. When tender is not required, tender is not required when the lien never attached, the instrument is forged, the assignment is void, the statute of limitations expired, the demanding party lacks authority, the agreement was ultra vires. Courts do not require people to pay ghosts. Tender versus loan mod trial payments. Trial payments are not admissions. Authority must exist before performance. Conditional approvals, binding contracts. You don't have to perform under a contract that was never legally formed. The danger of paying the wrong party. Waiver arguments. Estoppel traps, ratification claims, resetting statute limitations, undermining quiet title claims, Payment can sometimes legitimize what was otherwise void, so don't pay it if it's not somebody you should pay. Okay, so let's look at moral obligations versus legal obligations. You want to pay, and you want to be legally required to pay. Courts decide law, not morality. Tender doctrine is legal, not ethical. Courts enforce rights, not guilt. So, before tendering payment, do I know who owns the debt? Has authority been proven? Is the lien valid? Am I creating admissions? If the answer is no, pause. Demand proof of authority. File a quiet title action if you have to. Ask for declaratory relief. Seek injunctive relief. And in rare cases, deposit funds with the court. And most people don't do that even. So, the common myths. If I don't pay, I'll automatically lose. Trial payments prove good faith. Services can modify loans. Tender is always required. These are all myths, guys. Don't listen to any of these things. Tender is not a shield, and it's not a sword. It's a doctrine that applies only when authority exists. Payment follows authority, never the other way around. Now we have some case law. You can look at this case. It's Dimrock versus Emerald Properties. It's a foundational case in California law that clearly articulates the exception to the tender rule for void foreclosure sales. It establishes that when a sale is conducted by a party with no legal authority to act, the sale is void from the beginning, and the borrower can challenge it without first tendering the debt. So that's a good case to study if you want to get into it and you're in California and you haven't been paying your mortgage. Okay, let's look at an example. This is a New York case, and if you look, this is a corporate assignment of mortgage. And you look here closely, the date of the assignment is June 13, 2019. The assigner is MERS as nominee for IndyMac Bank, FSB. Okay, and the assignee is Nation Star Mortgage, doing business as Mr. Cooper, as you can see there. So, in this case, the assignment, they look at the recording date, June 13, 2019. That seems a little weird, right? Well, let's look at this. Let's look at what AI is saying about IndyMac. It's saying that it ceased to exist on July 11, 2008, when it was closed by and the regulators, and the FDIC took it over, and it basically went to One West Bank, March of 2009. Okay, so does that mean in 2019, when this assignment was recorded, the assignor did not exist, right? Think about it for a minute. When this was recorded, IndyMac did not exist, and MERS cannot assign by itself. It has to have a lawful assignor. So this assignment is invalid. And the original note, which is to IndyMac, if you look at the last page of it, it says, pay to the order of without recourse, IndyMac Bank. So it's a blank endorsement, which means it's bearer paper. But that's not enough to have authority. Anybody can claim ownership of this note. And Mr. Cooper is nowhere on here anywhere. And the assignment basically is void. It's not voidable, it's void. So in this case, should this person be paying their mortgage? No. Again, the problem. They were shut down. IndyMac ceased in 2008. They were shut down, placed in FDIC receivership, and sold to One West Bank in 2009. They do not have authority. So it's void, not voidable, as we can see here. So they had MERS has no agency, no authority to sign anything, nothing to convey the result. This is not a defect that can be ratified, cured, or waived. The only way this can be fixed is by quiet title action. In this case, the defendant filed counterclaims and a motion to dismiss to get rid of it, because there's no way this bank has standing to foreclose. Another interesting thing that you guys need to look at is the mortgage follows the note only if the mortgage exists. And here, the mortgage transfer is void. A void mortgage assignment cannot follow anything. Why tender is not required? Tender is required only when the foreclosing party holds a valid enforceable interest. So there you go, guys. I hope this information has been real informative. And thank you for subscribing to my channel. I hope everyone has a happy new year. And God bless.